Good morning, afternoon, and night, everyone. My name is Susana Santos, LCC Arbitral Secretary, and I would like to welcome you to the Singapore International Center and the National and International Arbitration Center of the Lima Chamber of Commerce, Memorandum of Understanding, Signing Ceremony, and webinar titled Advantages and the Future of International Arbitration. We are very excited to announce this collaborative alliance between SIAC and LCC. This partnership will enforce our goal to promote international arbitration as an effective and efficient method to resolve domestic and cross-border disputes. At the start of these sessions, SIAC and LCC will be holding a virtual MOU signing ceremony. For this purpose, I'd like to introduce Ms. Marianela Ventura, General Secretary of the Arbitration Center of the Lima Chamber of Commerce, and Ms. Gloria Lim, CEO of the Singapore International Center. It is a real pleasure to share this opportunity with you, and with no further introduction, we will start the signing ceremony.
Hello, good morning to all our audience from Peru, 8 and 2 in the morning, and good morning to our audience in Singapore and elsewhere, and welcome to our ceremony of a signature of the MOU with SIAC and webinar. We are very happy to be here today to sign this MOU with Gloria Lim, CEO of SIAC. SIAC is, I would say, the most important arbitral institution in Asia. Recent surveys and international arbitration have placed them on the preferred seat, at least in the Asia, and the second preferred seat in the world. It has been established in 1991, whereas LCC in 1993. So both of our institutions share a long experience in the administration of arbitrations. And this is why, and also together with the fact that there has been an increasing investment and trade activity between Latin America and the Asia Pacific market. These reasons are the ones that pushed us to move us with this interest into entering this MOU, with the hope, with the wish to share common experiences, know-how, to develop best practices together. So as a matter of fact, I would like to comment, though we will be signing this MOU today, already last week, we were sharing some know-how on, for example, on scrutiny process. That is a process that SIAC has already for 15 years, and that we, LCC, are studying as a new initiative. So we have already, in a way, have put this agreement, that this collaboration that we will be signing today, but it has already begun to work. Gloria Lim, would you like to say some words?
Yes, thank you so much. LCC Secretary General, Ms. Marianela Ventura, and to all our viewers, very good afternoon, morning, and evening, wherever you are in the world. And really thank you for taking the time to join us today for the SIAC-LCC webinar and this MOU signing ceremony. On SIAC's part, we are really delighted, that we are entering this MOU with LCC. And it is really a framework for future cooperation between our institutions to promote international arbitration as a preferred method for resolving international disputes. And as Marianela had said, Singapore and Peru share very strong economic ties, and it goes back quite a long way. We have a free trade agreement with Peru in 2009. We signed that. It gives Peruvian and Singaporean companies access, right, to each other's market and helps to enhance our trade investment links. And in 2018, Peru was Singapore's 12th largest trading partner of the 33 countries of Latin America and the Caribbean. And we've seen bilateral trade between Peru and Singapore thrive and is very vibrant. And in January this year, actually, Singapore was the first country with whom the Pacific Alliance countries, which includes Peru, have collectively signed a free trade agreement. So there are a lot of trade links. And with increased cross-border transactions and trade, we think it's essential to have a trusted international dispute settlement mechanisms in place, right, to support swift and efficient and effective resolution of commercial and trade disputes that arise from time to time. So, given arbitration's importance, SIAC looks forward to working with LCC through this MOU to jointly promote international arbitration, especially for cross-border commercial projects and investments. And we are also looking forward to working closely under the MOU. As Marianella said, there are many things that we have under the MOU that we will collaborate on jointly. Firstly, to organize, conferences, seminars, and workshops like today's, and also invite members of our communities to attend and participate in major events organized by both organizations. And we also contemplate, helping each other with hearing facilities on preferential rates. And we really look forward to working closely with LCC on all these and exchanging further in terms of know-how and experiences in arbitration. So we are very excited and we really look forward to future collaboration opportunities with LCC. I would also add that we now have an Americas office in New York. And that's an important milestone for SIAC. It is our fifth overseas representative office and the first one that is outside of Asia. And Adriana, who is going to speak later, she is heading up that office, and we hope that will serve to further promote our activities in North and Latin America, and also enable us to have a lot more close collaboration with you. So on behalf of SIAC, I really want to thank Marianella and the team for working with us on today's event. Our very first, I would say, event under the MOU immediately, and my appreciation to all the online guests and participants for joining us today. So I look forward to the discussions, and thank you once again.
Thank you very much, Gloria and Marianella. Now it's time to sign a copy of the MOU. And maybe we can take a quick picture after that.
Okay. Great. Okay.
Yeah, thank you once again, Gloria and Marianella. And that would conclude the virtual MOU signing ceremony. Now we'll start the panel discussion of the advantages and the future of international arbitration. I'm pleased to announce today's panelists. Please welcome Mr. Kevin Nash, Ms. Adriana Hewson, and Mr. Oscar Escurra. Kevin is the Deputy Registrar and Center Director of the SIAC. He holds a BA from Mount Allison University, a JD from Usgood Hall Law School, and an LLM in International Commercial Arbitration at Stockholm University. Adriana is the head of Americas of the SIAC Arbitration Center. Adriana oversees SIAC activities in North and South America. She has broad experience as an arbitrator arbitration practitioner, having acted as an arbitrator, international arbitration lawyer, and SIAC Secretariat Counsel. Huáscar is a member of the Arbitration Council of the LCC Arbitration Center and a partner in Bullard, Falla, and Escurra Abogados. He holds an LLM in Yale Law School, and he has a vast experience in teaching subjects such as economic analysis of law. Marianela will also be joining us in this panel. Marianela is the General Secretary of LCC, and she holds an LLM in International Commercial Arbitration at Stockholm University. Today's topic is the advantages and the future of international arbitration. I'd like to introduce this topic by stating that arbitration as an alternative dispute resolution method has evolved over the years. Some may think that arbitration is being obviated and replaced by other ADR methods. What do you think about this statement, Adriana?
Thank you, Susana, and good evening from Singapore to everyone who's tuned in. As Susana mentioned, I'm Adriana Usan, and I head up the Americas office of the Singapore International Arbitration Center. And before answering that question, Susana, I would like to thank everyone who's joined us to witness this special moment, which is the partnership between CCL and SIAC to promote international arbitration. Now, going back to your question, Susana, I think while international arbitration is still the preferred method of resolving cross-border disputes, well, that's at least according to the latest Queen Mary's survey, I think we should be mindful as well of other ADR methods that are increasingly taking on characteristics traditionally associated with arbitration. I remember an article written by a friend of mine. Her name is Eunice Chua. She's the CEO of the Financial Industry Dispute Resolution Center. And in that article, she pointed out that in the last decade or so, we're seeing specialized courts that are focused on hearing cases arising from international commercial disputes that have mushroomed across the world. So there is the Dubai International Financial Center. There's the Qatar International Court and Dispute Resolution Center. We have in Singapore, the Singapore International Commercial Court. In China, there is the China International Commercial Court, and others in Europe, such as Paris International Chambers, Frankfurt International Chambers, and so on. So these international courts have borrowed from international arbitration in various aspects. And for instance, they have introduced specialist or expert judges. And we know that in arbitration, this is considered the top perceived benefit of arbitration. And at least that's in the 2013 Queen Mary University survey. These specialized or international commercial courts also permit confidentiality. Again, another valuable characteristic of arbitration, and party choice in relation to procedural and evidential rules. This is, again, another price aspect of international arbitration that these international commercial courts have adopted. Now, the Singapore International Commercial Court, for instance, allow the customization option through the agreement of parties. So parties are able to opt out of appeals. They're able to agree to replace Singapore's rules of evidence with other rules. Some of the international courts also allow for foreign representation similar to arbitration. And the future development in this regard, such as the Hague Judgment Project to develop sort of a New York Convention equivalent of the enforcement of foreign judgments, I think further blur the line between international commercial courts with arbitration. Then, there's also Singapore Mediation Convention that promotes the widespread international enforceability of settlement agreements, which some would say directly erodes the advantage of arbitration, considering that enforceability of arbitral awards is usually ranked as arbitration's most important feature. Now, we are also seeing a new breed of dispute resolution emerge with contributions coming from blockchain, online dispute resolution, and machine learning. So algorithms, some believe, can automate dispute resolution proceedings up to a point where the claim will be handled by a chatbot and decided by a robot judge. I think currently arbitration still remain the preferred cross-border dispute method. There still remain certain fundamental features that distinguish arbitration from other ADR methods. For instance, none of the international commercial courts has gone to the extent of offering the parties the ability to choose their arbitrator or their adjudicator. And New York Convention is still one of the most successful treaty in private international law. So I would say in response to your question, Susanna, is that rather than viewing these other alternative modes of dispute resolution as competition, I think these modes can complement one another. For instance, SIAC has developed what we call, and I think we discussed this earlier prior to this panel, the arbitration protocol to combine the benefits of arbitration and mediation, where parties are able to have their mediated settlement agreement executed as a consent award to make it enforceable under the New York Convention. The Singapore International Commercial Court is also seen in Singapore as complementing instead of competing with arbitration, as it provides support in arbitration-related court proceedings. Now, we are not certain, of course, what the future would look like, but having said all of that, we should be prepared with the possibility of the further blurring of lines between arbitration, litigation, and mediation, which at the end of the day really is not a bad thing as long as it serves the user's needs. And as regards what I mentioned about blockchain and machine learning arbitration, I think technology is unlikely to displace traditional arbitrators. What we might see, though, and we should be prepared as institutions, is that there might be a fragmentation of market into different tiers where arbitrators will probably decide high-stake cases and perhaps using machine learning to automate resolutions of low-value claims might happen in the future, so we don't know. So what institutions like us should do is to continue to focus on meeting the evolving needs of end users. We should think of creative solutions for increasingly complex problems, while of course addressing perceived shortcomings of arbitration. I'm sorry, I think that's a very long answer to your question, Susanna.
No, thank you so much, Adriana. That's a very interesting point of view. Kevin, what's your opinion about this matter?
Yeah, I would echo and second everything that Adriana had to say, and I've heard Adriana say it before, and I would completely agree with this as well, is that as dispute resolution professionals, as arbitral centers, we are in the business of resolving disputes. There are going to be certain disputes that are perfectly appropriate for arbitration. Some would be better handled by mediation, some by international litigation. And an emerging trend that we see is how some of these dispute resolution mechanisms can work together. So it's not unusual in terms of SIAC's case portfolio. In a construction dispute, you might have an adjudication, which will then go to arbitration. You could have a period of structured negotiation that then goes to arbitration. And there are some important considerations from a case management standpoint and from a tactical standpoint of setting these preconditions to arbitration. So the position in Singapore is that if you set a clear period for, say, structured negotiation, you are likely going to be bound to that bargain. The courts will likely give effect to that agreed period of negotiation. If you try to file an arbitration within that period, it could potentially bring issues of admissibility. Now, merging these different forms of dispute resolution, as Adriana said, I think this is a very good thing for dispute resolution. They certainly do not compete. We see Singapore as a jurisdiction where you can resolve any kind of dispute. And it's not just international commercial courts borrowing from arbitration. We are all borrowing from each other. I think a very good example in terms of the SIAC rules is the introduction of our procedure for the early dismissal of claims and defenses. So we are quite open from having borrowed this from ICSID under Article 41 sub 5, but really what it is, it's the common law litigation mechanisms of summary judgment and striking out. And so we had a call from our users, notwithstanding that this power already existed inherently with tribunals to deal with claims at an early stage, but we thought that this could further streamline arbitrations. So if you had a wholly unmeritorious claim, instead of going all the way through the arbitration, perhaps that claim you could have summary judgment at an early stage. And on the other end of the spectrum, say from a respondent side, if you had a respondent with counterclaims that were squarely outside of the four corners of the arbitration agreement, perhaps some of these counterclaims could be struck out. And everything we're doing, whether it's rules, borrowing from different dispute resolution procedures, everything we are doing is to try to give effect to the core features of arbitration. There is always going to be a reason why parties choose arbitration to resolve cross-border disputes. Parties choose arbitration because it is customizable, the principle of party autonomy. You get to choose your deciders. Confidentiality, which we'll be talking about a bit later, the fact that there's limited avenues of appeal, international enforceability under the New York Convention. We all know these advantages of arbitration, and all of these procedural mechanisms that we introduce in institutional rules are to give effect to these core principles of arbitration. So even though the dispute resolution marketplace is becoming a bit more crowded, and perhaps there's some blurring of lines, arbitration still remains the preferred method of cross-border dispute. And I think that we're getting better by being able to combine with other dispute resolution methods and adopt some of the procedures within those other dispute resolution methods.
Thank you so much, Kevin. Marianela, could you share with us your thoughts about this?
Sure. Actually, I couldn't agree more with what Adriana and Kevin have said. I believe that because of the key features of arbitration, flexibility, party autonomy, and all the other characteristics, we know arbitration comes out of the pandemic actually with more strength, and it reflects in the White and Case latest survey. It's still for 90% of respondents the preferred method of ADR. But it is interesting to note that this is in conjunction with other ADR is 59%. So I totally see this trend at an international level, the fact that there might be tier clauses. Now, going to the LCC cases that we have been receiving, and the Peruvian context also, I see that arbitration keeps growing for many reasons. It might be because of its advantages, because also a judiciary system that lacks in efficiency, also because of national regulation. This all helps that to the arbitration keeps growing. However, I must say that I have also noticed that, for example, in Peru, that it's a traditionally litigation trended market. Let's say our users are used to the litigation, to arbitration, and not using the other ADR methods, are now beginning to see with other eyes also other mechanisms. And this is also the reason why in LCC, since 2020, we launched a new service, which is dispute boards, and with the aim precisely to be previous and to any arbitration, and perhaps more with another mindset of more trying to avoid conflicts, trying to solve potential, to detect potential issues in the construction projects and solve them prior to going to any arbitration. And that also will benefit the commercial terms and also avoid the paralyzation, the stop of the construction. So I see that our users that were usually litigators are now beginning to see that other mechanisms, more conciliatory, may have many benefits. So, and this is very good. And I also feel that our users are beginning, are getting more sophisticated with the ADR methods. And this is very good for the society and also for us as an institution, because it pushes us to get always better and try to listen them more and their needs.
Thank you, Marianela. Huáscar, I believe you have different perspective on the arbitration community. Could you tell us, please, your opinion about this?
Thank you, Susana, and thank you for the invitation. Very happy to be here. In my view, when I compare the reality that Adriana and Kevin just explained to us, for me it is clear that the menu of options that businessman has in their case is completely different than the menu of options that businessmen have here in Peru. They explained to us that courts or mediation or arbitration are the options there, and they are even complementary, and they do attend client needs, and it depends on the case and the client needs, which is the option that the client finally gets. Here in Peru, the menu of options, I would say, is very limited. You have courts or arbitration. And of course, businessmen prefer arbitration because arbitration is more predictable, is an option in which you appoint the authority that will decide the case. You have that power. You don't have that power in the court, and it's less costly as well. Of course, that's the preferred option, but here you don't have the option of mediation. I will not say that there is a market there for clients to go. Our culture, as Marianela said, is very a litigation culture. So my question, and I don't have the answer, is what do we need to do in order to create this market, the mediation market? I mean, for example, law firms here in Peru do not have practitioners, experts in mediation. Even big law firms, we don't have that area. And that is something we need to create, because I am sure that for many of the cases we try here, it would be better for clients to go for a win-win solution, which is less costly, than go for a win-lose alternative that will take 2 years and is very costly. So if it is the case, clients don't go to mediation here, is because the market has not been created already. And I do think that we need to work on that with the Chamber of Commerce of Lima and with the law firms here in Peru, and create that option that is really needed. That's my view.
Thank you so much, Oscar. Let's move on. The sanitary global crisis has forced us to make a number of changes in our ordinary lives. Arbitration and other ADR were not the exception. The pandemic has created a need to improve the administration of our cases, and the best way to do so was by increasing the use of technology. What are your thoughts on this matter, Adriana?
Thanks, Susana. I mean, the pandemic has certainly accelerated the use of technology in arbitration. It helped users, arbitrators, and institutions like us to streamline our processes and improve the cost effectiveness in the process. SIAC is responding to this increased interest in the use of technology and has quickly adapted to life during the COVID-19 pandemic. We have an internal case management system, which automates many of the procedures and allows our staff to actually work remotely. We are also currently designing a secure digital platform to further improve the user experience, so watch that space. We also have added a live chat feature on our SIC website as an added channel for parties to reach us. To promote and facilitate the use of virtual hearings, we have also introduced a user-friendly checklist to help users navigate the use of video conference. And of course, our rules is broad enough to provide or to allow the use of virtual hearings. That's under our Rule 19. And I think Kevin would be a better place to speak on the amendments to our future iteration of our SIC rules with respect to the use of technology.
Of course, Kevin, would you like to share your thoughts about this?
Sure. The increased use of technology during the course of the COVID-19 pandemic has actually made me very proud of institutions, the way that institutions are working together to solve problems. When the lockdowns in the various jurisdictions first happened, I was actually wondering how dispute resolution would proceed, whether hearings would be put off for an indefinite period, whether it would just be those small value, less complex cases that would be taking advantage of virtual hearings. But the result in Singapore, at least, and at SIAC, and I think for institutions around the world, is that parties have adapted very quickly to using technology. So the biggest result has been virtual hearings. But this technology has actually existed and has been deployed in arbitrations for a very long time. The difference is that it might just be, say, an expert witness or a witness of fact. They would be participating by virtual means, and then you would have the rest of the arbitration participants in person. But now we have three very good possible situations for hearings. You can have a fully virtual hearing, which we certainly see a lot of, and we did have the advantage of having very broad language under the SIAC rules. You can have a hybrid hearing, which we see a lot of in Singapore, and then an in-person hearing, which is also continues to happen in Singapore. And what these virtual hearings are doing, or the flexibility to have a hybrid hearing, is giving effect to one of the best advantages of arbitration, which is to get quick and cost-effective justice. And so sometimes, in the interest of being provocative, I will put out a rhetorical question of whether there will ever be a case management conference in person again, particularly if you have an international case portfolio where you might have multiple parties, witnesses spread around jurisdictions. Do you really need to fly in for those interlocutories? So it might be the case in a very high value dispute where the interlocutory hearings would be done by virtual means, and then the physical hearing might be in person. So this has actually been a very good thing for arbitration. And I suppose that there are some potential issues. Tribunals do have to be prudent and mindful in terms of a virtual setting a virtual hearing protocol. There's lots of guidance that has been put out by all of the institutions. And then from an institutional standpoint, emerging issues that we have to look at is what are we doing to make sure that we have our cybersecurity protocols in place, data privacy and confidentiality. These are big issues for institutions that we are looking at very closely. It has also, I think, been very helpful, this leveraging of technology, in addition to streamlining the actual conduct of the cases, but it allows the institutions, in terms of our thought leadership initiatives, to really be able to reach people from all corners of the globe. I say quite often at the SIAC annual event that we had 10% of the attendees were from Africa. We are able to have the conversations that we're having right now, and us as institutions, we can get together, be seeing each other, and talk about the scrutiny process. So in terms of being able to engage in training, capacity building, dissemination of information, the ability to participate virtually has been very important. From a relevant standpoint in terms of our case management, it's also assisted with the appointment of arbitrators. I can remember, say, a decade ago when we were appointing an arbitrator, say, with a Singapore seat where the venue is Singapore, you would appoint an arbitrator from Latin America or North America only on the very high value cases, or when there was a nexus with North America or South America. Now, because the world is quite small, because of the ability to participate virtually, we are able to appoint the best arbitrators in the world wherever they are in the world. And it's the same thing with the participation of counsel. Regardless, if you had a law firm, say, in Peru, they might be co-counseling with one of the local firms in Singapore, but they can also be participating as counsel in proceedings where there's a Singapore seat and there is that, say, connection between Latin America and Asia. One thing that I guess that as institutions and dispute resolution professionals, we have to make sure that we are properly harnessing technology. So we certainly want to innovate. A failure to innovate, I think, in this time would be tantamount to not competing. But we want to make sure that technology is making the processes more efficient. not technology for the sake of technology. And it involves a lot of change of mindsets as well. There are parties and counsel that still want to have those A4s. They want to be able to feel the documents. So part of what we have to do as institutions is introduce these options of ways that we can make arbitration potentially more efficient, but also be mindful that that capacity and technological access might not exist for all parties, and always have the idea that we're doing this to make arbitration more efficient and a bit more streamlined.
Thank you, Kevin. Marianela, do you agree with Kevin? How was the experience in LCC?
Yes, I very much agree. In our case, with respect to case management, we had modern rules of 2017 that allow the process, the arbitration process, to be 100% technological and embracing technology and virtual. However, the practice in our market was not that. So the work that we had to do together with the Superior Council of Arbitration was to change the culture, the practice of our users to embrace technology. So in April 2020, the Superior Council issued a practical note by which it established how users should adopt technology in the different phases of our proceedings. And it had a good, a positive impact, I must say, because this is also because we have different types of users. Many of our users are private corporations, but also we have many also entities, public entities, which perhaps did not have the means or did not have the practice to use technological means as much as others did. So we had this process of implementing this practical note that went together with the work of the Secretariat. We did many webinars to help our users in this migration of practice, and we're always there for them for any advice or any clarification that they might need. And it had a really positive impact. Now we have all our proceedings that are held with the electronic means. And actually, even though our center is open to have physical hearings for many times, we haven't because our users, and many of them still being here in Peru, they're still preferring until the moment having the hearings virtually. In that moment, I believe that they will begin some hearings to be in person, as Kevin was mentioning, some that, for example, also might be with the expert witnesses or some more important hearings that might be in person, but until the moment we don't have them. People are still preferring virtual hearings. And I have to say that we are scheduling almost the double of the hearings that we had before, because it gives to arbitrators more availability, not having to travel throughout the world or throughout the country. So they have more availability, so it's easier to schedule hearings. So yeah, I think that we have this change of mindset in our users. Of course, this goes together with work. We have different protocols for the hearings and always there for our users.
Thank you so much, Marianela. Oscar, as a user and as a member of the Council of LCC Arbitration Center, I would love to hear your opinion about the implementation of technology in arbitration.
Yes, thank you. I completely agree with what I have just heard. I mean, one of the good things of the pandemic is that the pandemic gave us no option. There was only one option, you go virtual or you go virtual. And that was great now that I have experienced virtual hearings and processes managed completely virtual. I mean, at the beginning, I was, of course, scared. I was skeptical about the possibility of having a cross-exam and making the energy you need in the room in order to have an impact on the tribunal. I thought that was not possible virtually. I thought that persuasion was going to be affected if your communication was going to be virtual and not physical. I was mistaken. Now I can tell you that virtual hearings for me are even better than presential hearings. First is better for the client, less costly and quickly. And they do want less costly and quick justice. So their need is attended better now. And second, the effectiveness of the hearing is, in my view, even better. You can manage documents with the Zoom and present the document while you are doing the cross-exam easily than before this new world. You can see the witness closer. The camera gives you the possibility to look at the eyes even better than in a physical hearing. The work of reading the eyes of the tribunal, reading the eyes of the witness, we are learning. I'm still learning. From what I have learned today, I can say that this is the better way to go. I don't think we will go back. The only reason we have some presential hearings is because there are some generations for which going virtually is too much a change. We are in the process of changing culture, and of course this process takes time. But at some points, I can tell you, we are not going to have presential hearings. It makes no sense at all.
Thank you so much, Oscar. Now, I would like to address one of the most common yet important topic in arbitration discussions, the transparency of arbitration. And now I would like to start with Kevin. Kevin, what is your point of view with the secrecy culture of arbitration? Do you think that confidentiality is still important to users?
Susanna, I like the way that you put it in secrecy, the secrecy culture, because that can be an interesting exercise to maybe help how we look at confidentiality. What is the difference in impression you have if you call it confidential versus secret? So confidential seems like a pillar of arbitration. I think when you call it secret, even if it's the same effect, then it starts to make users a bit more uncomfortable. To further frame the discussion, when I'm talking about confidentiality and transparency, I generally look at it in two ways. So you have transparency within the proceedings. That's the institution communicating, say, reasons for its decisions, how they have exercised its discretion to the parties to the arbitration. And then you have public transparency, which may, say, take effect by the publication of redacted awards, redacted decisions on challenges, procedural decisions, and both of them are important and in different ways. And there's also a question from a confidentiality standpoint. Is this something that should be opt-in for parties or opt-out? Should an institution be able to publish redacted versions of awards as a matter of course, or should they require the consent of the parties? What we've done at SIAC is that we seek the parties' consent prior to publication. So we ask the parties whether they would be agreeable to SIAC publishing redacted versions of the awards. And in this way, we had previously published a volume of redacted SIAC awards. I think it's important for us to try to do more, to try to show users the kind of things that are happening in SIAC arbitrations, and particularly when it involves the interpretation of say, a procedure under the SIAC rules. We're very happy that there have been quite a few books written on the SIAC rules where they're offering interpretation, how these rules are going to be interpreted. But one of the best things you can do is show how tribunals are actually deciding these cases. I think that in Asia Pacific, there is a bit more of an emphasis on confidentiality, where this is important to users. So it's one of those things where some users may want to advance the arbitration scholarship by having an institution publish redacted versions of the case, but it might be on someone else's case. When it's their case, they want it to be confidential, but on someone else's case, then maybe they're more agreeable. So we want to be a bit careful about how we're doing it. In our pre-panel discussion, we were discussing listening to users. So making sure we do what users want. And that's one thing that we've focused on very hard over the years, is making sure that we're doing things that users actually want. So in our last revision of the SIAC rules in 2016, and with the SIAC investment arbitration rules, which actually have very interesting provisions on confidentiality and transparency, I call it a common sense version of transparency in terms of what SIAC can publish as a matter of right and what we can only publish with the consent of the parties. Of course, different considerations in investment arbitration. But to the point, we want to listen to what users actually want for confidentiality. And transparency. That's very difficult for us as well, because we've had parties from more than 100 jurisdictions in the past 5 years. So in this revision of the SIAC rules, where we'll be looking at updated provisions on confidentiality and transparency, we want to listen to our users. What are the in-house people saying? What are the counsel saying? What are the arbitrators saying? And then we'll probably have an update. But I think the general tenor of things, both for transparency within the proceedings and public transparency, is to have more of this. Less of that institutional curtain, the institutional haze, where parties don't know exactly what's happening within the proceedings, and then the scholarship is not quite being advanced. I think the trend and the movement is to having more transparency in both areas.
Thank you, Kevin. Adriana, I would love to hear your opinion about this.
I would echo what Kevin just said. I believe there is this tension between confidentiality and transparency, and there is this demand more and more to be transparent. And I think for us, at least at SIC, confidentiality and transparency are not necessarily opposing concepts, and it is possible to achieve the right balance between the interest of arbitrating parties that want confidentiality on the one hand, and greater transparency on the arbitral process, like Kevin mentioned, on the other hand. So at SIC, while we ensure the confidentiality of the proceedings from the public, say the award, we are also increasing the transparency of our internal processes, such as appointments and decision and challenges to the parties involved in SIC cases. But like what we've discussed earlier, the pre-panel, Huascar said, we should also listen to our users. And so we're quite open to the feedback and what the market wants in terms of confidentiality and transparency. And while confidentiality is an important feature of arbitration, it really varies case to case. So for some companies that need to disclose their shareholders, the dispute, or disputes that do not involve sensitive commercial information, confidentiality might be less important, weighed against the benefits of having more transparency, creating some sort of precedents, if you may, and just to increase the reliability of arbitration. So I guess that's the balance that we're looking at. Thanks, Susanna.
Thank you, Adriana. Marianela, please, could you share with us how has LCC managed transparency over the years?
Yes, well, let's say around 2017, 18, because external events, the users, I would say in Peru, but also in the region, began to demand for greater transparency, but especially with respect to the process, okay, and arbitrators in particular. So because of this, LCC launched in 2019 a software that is lodged in our webpage that is called the Transparency Lighthouse. In it, we publish, so we put for public use with no cost information, particularly with respect to the track record, let's say, of the arbitrators that have had cases in our institution since 2012. So one a user, an interest party may see, for example, in the arbitrators, if they're planning to appoint a certain arbitrator, they might see if that arbitrator, how many cases ongoing has that arbitrator, and whether he is the president of the tribunal or sole arbitrator or arbitrator, and how many cases that arbitrator has already had in our institution, and what is the average time that the arbitrations in which he is part take to issue an award. In this, of course, we take out the time that the arbitration is suspended for any reason. So that does not affect the track record of the arbitrators. That is a question they always ask me. But apart from that, users can also see whether that certain arbitrator has shared in the past years tribunal with other arbitrators, or if that arbitrator has been appointed by a certain law firm more than 3 times in the last 3 years. It can also see if that arbitrator has had any sanctions by our Court of Arbitrations, whether he has been challenged in arbitrations, and if that challenges have been grounded or not, and also if he has awards that have been set aside. And also that is as much as we have done with respect to transparency with regards to the arbitrator's record. And then, of course, I share with Adriana, with Kevin, with respect also to confidentiality and then of the awards that we feel that is still important for our users. So what we publish is the awards that have had one public entity involved, because that here in Peru by law they are public. But in case of private parties, we, in most interesting cases, we do publish some redacted awards. We have the authorization to do that in our rules. So the parties, by entering our rules, kind of give us our authorization to have the redacted awards published, of course, maintaining the main elements confidential. So that is how we deal in the CCL with this issue. And we're always trying and to see what else we can publish or can be of interest of the users.
Thank you so much, Marianela. Oscar, the time is cruel, but I would like to hear your opinion about this matter as a user. Do you think that confidentiality is still important to users?
Thank you, Susana. Going to the point, as Kevin and Adriana explained, listen to the client is key. I mean, as in any industry, you need to listen to your client. And in my view, the claim for transparency, I agree, is the new trend. That's the strongest claim of the last years here in Peru, more transparency. Confidentiality has been an assumed topic. Arbitration is confidential. Okay, so nobody worries about that. And when you are growing in terms of giving them, the client, more transparency, if that prejudices in some part confidentiality, in my view, and this is just my view, client, don't worry. If it were to make a decision, the client will prefer more transparency, even in the case this prejudices confidentiality. Because at some point, there is an overlap between those two. We need to work more on transparency. We need to work more on listening to the client needs. And in my view, what the Chamber of Commerce of Lima has done is extraordinary, but it's not enough. We need to do more. We need to work together with the Pontificia Universidad Católica Center of Arbitration, with AmCham, with all the other centers of arbitration. I have a common link in the website in which you can access to all the information of the relations of arbiters with lawyers, arbiters with other arbiters, arbiters with the subsidiary of the company, arbiters with the parent company. Clients need more transparency. That's the strongest claim of the last few years, and we need to work more on that. What we have done is great, Marianela, but it's not enough. It's not enough. Thank you.
Thank you all for this conversation. Finally, to end this session, Mr. Huáscar Escurra will make some closing remarks. Huáscar, the floor is yours.
Thank you. Thank you. I just want to say thank you to the SIAC, to Adriana, Kevin, and Gloria for this opportunity. First, to sign with you guys this memo, this Memorandum of Understanding. I am sure we have a lot to learn. One of the best things about the technology, as you explained, is the possibility of having a strongest exchange of knowledge. This brings us the opportunity of this exchange of knowledge with you guys, and this will give us the opportunity to improve our practices in arbitration. I am sure we have a lot to learn. Seeing what you have done is like taking a look to the future, to our future. You will guys give us the possibility to take a look at what we can do if we work together. So I am very happy with this initiative of Marianela and the Chamber of Commerce of Lima to sign with you guys this Memorandum of Understanding. We have a lot of nice projects. One of those is the scrutiny of awards. This topic was discussed with Kevin. Maybe you don't remember Kevin, like 2 years ago in a conference we organized with my law firm. And I am very happy. This is the result of that exchange of knowledge in a way. And I am sure that our project of scrutiny of awards has all what it needs in order to be able to bring our clients a more effective system of resolution of disputes. About the topics we discussed today, I think these are dead topics. I mean, technology is already here to make our lives better and the lives of our clients better. I don't think we're going back. We have to learn to make a nice cross exam virtually. That's the best way to go, and it's possible. We have to learn, if you are an arbiter, how to manage all the arbitration virtually. That's the best way to go. Why? Because that's what our client needs, and you need to follow your client needs, as in any industry. Again, confidentiality, transparency, I have no doubt that confidentiality is more a myth than a reality. The real topic is transparency. Clients need transparency. If we want arbitration to survive all the critics that the community make to arbitration here in Peru, mainly the cases of corruption, which are a few, but there are some, the best way to answer to our critics is more transparency. We need to work more on that. Nothing more to say. You guys already said and make the most important points of today's meeting. So thank you again for this opportunity.
Thank you, Oscar, and thank you, Marianela. We also look forward to this very productive MOU signing and relationship moving forward. Perhaps Gloria would like to say some final words.
I just want to thank everyone for spending time together today. It's really a great start to our collaboration, and I really hope that we will have further opportunities in days to come to do a lot more together. So I wish everyone a great day ahead, and I really enjoyed today's discussion. Thank you to all our panelists.
Many thanks. Many
Thank
thanks.
you.
Thank you. Thank
Thank
you
you so
all.
much.